The next big one is discrimination. And that is the civil rights law, is the hottest one. And I want to tell you a little history about Title VII. It was done in 1964. The history was that people said, well, you know, we have to do some rights for those people that color, race, national origin, ethnicity, sex, religion. Sex was not there in the original document. They added it. The Southern congressman added sex and say, well, if we add sex, no one's going to believe this law, because how is there any discrimination about sex? And so they won't pass it. Well, as you all know, they did pass Title VII, the civil rights laws, and they did pass the word for sex, which has also been the law that relates to sexual harassment, which we've heard tons about in the news, which includes a hostile environment. So they passed this law, and they said you cannot discriminate on all of these things. How does this happen in an organization? Here's a few examples of things people have said which have gotten them in trouble and caused a lawsuit. An employer said, we don't hire young women because they leave to have babies. You don't want to do that. That's a lawsuit. We don't hire your kind, said another employer. Kind could reference religion, race, ethnicity, sexual orientation, whichever one it is. Again, if you can prove this, and you have a great lawsuit. Or the situation is a woman is not promoted and no women are in any supervisory positions because of the cultural bias that they are not strong enough to make the tough decisions. So if you hear that in an organization, you have a large organization, so there's more of a cultural atmosphere in a larger organization. And so if there's this cultural atmosphere that says women can't make the tough decisions, you've got a lawsuit here also. So those are the kinds of cases that could cause you problems for a discrimination, especially with civil rights. Now, if you have, every state is a little different how you report these things. But everyone can go to the federal EEOC, which is Equal Employment Opportunity Commission. However, in Kentucky, they do not have to go there. They can get themselves an attorney and go straight to a lawsuit. It's much more expensive than other states because they're going straight to a lawsuit. And you may have to pay the other person's legal fees if you lose. So how much is this happening? In 2018, the 19 figures aren't out yet, but EEOC handled 76,418 cases of discrimination, resulting in $505 million of fines and penalties. Of course, spread over all those people. That's a lot of money. Any business does not want to spend that kind of money. This included 24,655 sex discrimination suits and 24,600 race discrimination suits within that 76. But even if the case isn't won and someone puts a claim in, what it costs you as a business or an organization is morale issues, everybody's talking, your reputation of your company, and those kinds of things. The other thing is, one of the things that happens is people get upset that someone filed a claim of sex discrimination or race discrimination, and so then they go after the employee and retaliate against them. And every one of these laws says, thou shalt not retaliate. There were 39,469 cases of retaliation, which was 51% of the cases. So you didn't get the sex discrimination suit, but you did get caught on the retaliation. I had a case with an organization. The CEO sexually harassed a administrative assistant in an office. She filed the case, and they had to bring in witnesses. And one of the witnesses was a department head who reported to the CEO. But he saw it. He said, I saw it. I heard it. Yes, he did do that sexual harassment. So then the CEO fires the department head. So the organization had to pay for the sexual discrimination suit and pay it was $1 million, I think. And then they also paid out another $1 million to the retaliation suit. These things are happening. So you definitely want to be aware of all of the issues related to discrimination. And of course, the Me Too movement has made this a very important discussion. More and more people, and EEOC has said they have seen an increase in sexual discrimination and sexual harassment cases because people feel they can finally come forward and make those claims. So, additional discrimination suits are ADA, which is the Americans with Disabilities Act, and that was in 1990. That states employees with 15 plus employees cannot discriminate against employees who can perform the essential functions of the job with or without accommodations, as long as it doesn't cause an undue hardship for the agency. So an example of that is if you have an administrative assistant who has a hearing problem, you are required to get one of those phones that has the amplifier for it so that they can do their job. But if you have only one custodian in your organization and they can't lift the garbage, and that is the only person that does garbage, then that would be an undue hardship because you'd have to hire someone else to lift the garbage, and you only have one. So in small organizations, now, I don't know how many of you have children, but if you go to a school, they have tons of custodians working in all the different buildings, as you know. And so if one is hurt and can't lift, they can make an accommodation. But if you only have one and they can't lift, then they can't do the job. So, and ADA is very specific about what is the circumstances, and you really need to look at each one separately. There's no set rules that say, yes, you have to do this, no, you have to do that. Many people go to an attorney to sit down and say, well, this is what we think we can do. I can handle a lot of those cases myself, but occasionally it gets too complicated and I bring in attorneys to help me. The other hot issue lately is ADEA, Age Discrimination in Employment Act, and that was in 1967 also, back in the 60s, which says employers with 20 plus employees cannot discriminate against older employees. And an older employee in this definition is 40, which is interesting. As we get older, we're like, 40 doesn't seem old, but it is 40. And the reason is many organizations sort of push out the older employees because they're making more money. You cannot do that because the longer they've been there, the more they know, the more they get paid. So you can't eliminate older employees and see that pattern. If you can see that pattern that they're getting rid of older employees, you have a lawsuit. The same thing happens when, such as sexual harassment, we were talking about, people harassing the older guys. I've seen situations where people, let's say we have a place that has locker rooms for everybody to use. And so someone puts on the locker, hey, old man, you're taking up space. You're taking up all these young people's jobs. Those kinds of things. That's the same as a sexual harassment, but an old reference age. So the same discrimination kind of issues come to that kind of thing. And then we have the Pregnancy Discrimination Act. There's a federal and state. Kentucky just passed theirs also recently, and that's 15 plus employees. You cannot treat them differently in the employment action due to pregnancy. The law makes it clear that pregnancy is not a disability under the ADA unless you get a medical doctor's note that says they have a specific medical necessity to do something different. And then you have to make accommodations, just like we talked about with the ADA. So you can't make decisions because this person is pregnant. and treat them differently. So the best practices in all of these areas is to update your employee manual to make sure that you have language about equal opportunity and lack of discrimination and treating people respectfully, and putting all of that into some of these rules into your employee. But also, again, the job description, and we'll talk about that a little later. You can't write a job description that says only young people can do this job. That is discrimination. So definitely don't put that in your job description. So that's a whole bunch on the discrimination issues.